My Lord, back to paragraph 229. So, this is the crucial paragraph where court essentially reached the findings, the various reasons set out as to why the transactions were speculative, and a number of cases, as I showed you, are cited for each proposition. I'll come back to those cases in a separate chunk in a moment, rather than try to turn at each one individually. But what I want to start with is the consob determination, because actually we say, had this been properly applied, it would have been the end of the analysis. And paragraphs 2291 and 2292 of the judgment concern the consob determination, as you can see. And the consob determination is in the supplementary volume 1, tab 23, at page 169. And this is the Italian regulator answering a question. I think the judge describes that in his judgment. And in particular, it's clarified by the regulator right at the bottom of page 169. It is clarified that a transaction can be considered hedging when A, it is explicitly put in place to reduce base risk, B, there is a high degree of correlation between the technical and financial aspects of the hedged item and the financial instrument used for that purpose, and then C is the documents. Now, the judge held that the third of the requirements, C, wasn't relevant for present purposes, and we agree. So that's paragraph 207 of his judgment. So the key ones are A and B, and looking at B, it's clear from the language of this provision that it requires not an exact degree of correlation, but a high degree of correlation between the underlying borrowing and the hedging instrument. And we suggest that on the judge's own findings and given the terms of the contracts, this test was satisfied. And I've got 2 points on that. First of all, that the transactions were entered into for the purposes of reducing the exposure to a rise in interest rates under the Rialto bond. And the judgment makes that finding at paragraph 225, subparagraph 5. And the second point is that there plainly was a high degree of correlation, as indeed the judge's own judgment, as I showed you, demonstrates, and that was at paragraphs 225 to 228, and in particular, the correlation was between the amended Rialto bond and the transactions, being the duration, the notional amount, the amortisation schedule, and the interest rate payable by the banks to Venice.
And 2281, isn't it?
It is, in particular, is that point, my lord, exactly. And of course, we've already debated why the cap and the floor didn't correspond. And so what we say is, if you then apply that, the consob test is satisfied. Now, the judge didn't think so, and you see this at 2291 of his judgment. And what he says is the transactions are explicitly carried out into the terms adopted to reduce the risk connected with the Rialto bond and to cover the winding up costs, etc. So he says A is satisfied, but he doesn't think B is satisfied because whilst many of the terms of the transactions match the financial characteristics of the Rialto bond, important and financially highly significant terms were arrived at for other reasons. And I think that can only be, looking back at his 2281, the level of the floor and the cap. That, if they correspond, his 2281 and 2292. Now, my lord, we suggest that that is an error and that the learned judge didn't analyse the transactions properly or take into account the negative MTM as an existing risk for Venice, which was not speculative. And on this point, it is the case as well that Venice didn't seek to argue that the Bear Stearns swap failed the consob test. It's another point they didn't take. So, my lord, we say that if we're right on this, that would have been the end of it, because the expert evidence, we say, suggests that it would have been decisive to have applied that test. And can I give you the references to that, which are Professor Gentili's evidence for the bank was that the consob determination had become the de facto test for hedging under Italian law. And in support of that argument, he referred to a decision of the Italian Supreme Court, which held that the consob determination must be applied. And the references to all of that are in paragraph 59.1 of our skeleton. And Professor Gentili's report is in supplemental volume 1, tab 19, page 145, and it's paragraphs 2.1 to 2.19. And we say that given that there was no test laid down in Cattolica for what was speculation or hedging, this Supreme Court decision, together with the evidence of the experts, was sufficient. Venice's expert, Professor Alibrandi, disagreed with the suggestion of the bank's experts that the consob determination was determinative. But can I just give you an outline of that evidence? First of all, in her first report, and I'm not proposing to turn these up given time, but I can turn up anything the court, I should say, wants to look at. In her first report, at paragraph 121, supplementary volume 1, tab 9, page 83, Professor Alibrandi in herself cited the consob test. In her third report, she started to back away from that test, suggesting it wasn't exhaustive and that case law was more relevant. The significant development between her first report and her third report was that the speculation case was only introduced by Venice in between. But it matters not, because on cross-examination, she ultimately accepted that if the transaction satisfied the first two limbs of the consob test, then it would, quote, likely be hedging. That was her cross-examination. And the reference to that is supplemental volume 2, tab 64, page 667, line 21 to line 5 on page 668. So, at the very least, it was common ground that if the first two limbs of the consob test were met, then the transactions would likely be classified as hedging and therefore not speculative. And there was a Supreme Court authority on the point, which was not referred to in the list of cases cited by the judge. Now, my learned friend makes one further point on this, which is that he says that the wording of the consob determination requires a comparison between the risks arising under the Rialto bond and the risks arising under the transactions, and not a comparison between the Bear Stearns swap and the transactions. He tries to draw that distinction, and that's at paragraph 38 of his skeleton argument. And we suggest that's a bad point, because we fully accept the correct comparison is between the risks arising under the Rialto bond and the financial characteristics of the transactions. But there is nothing in the language of the consob determination to support the assertion that when performing this comparison, you ignore the fact that the bond was subject to a pre-existing hedge. And there is no authority cited by my learned friend for that proposition, nor it was, I would suggest, any principled basis. So, my lord, on that point alone, we say the judge's judgment cannot stand, because there was a relevant Italian test specified, advanced by the Supreme Court, which we suggest his own findings confirmed was met, and that the distinction on the cap and the floor was not a good distinction, and on that ground alone, the transactions were not speculative, aside from everything else I've said as well about the nature of them. So I don't really need to go through the remainder of it, but of course I will, because we say if I'm wrong on that, we would still succeed in any event. And can I then turn to the third paragraph of 2293, which is the significant difference between the MTM of the cap and the floor. And if we go back to 2262 of the judgment, you see that the judge found that the principal reason why the value to the banks of the interest rate floor was more than the cap was because of the encompassing of the winding up costs of the Bear Stearns swap. Now, we've already submitted on in dealing with transactions that the value of the cap and the value of the floor will never be equal to each other, because the bank will always be looking to cover its costs and make a profit for the transaction. So it's never going to be the position that they're equal. The floor and the cap are therefore calibrated to produce the mark-to-market in favour of the bank from inception. And what is clear is that as a matter of Italian law, there's nothing objectionable about that, because if there was, the banks would never be able to enter into a swap, because they would only ever be able to do it if they were priced in a way that caused the banks loss. And authority from the highest courts in Italy also confirms that Italian courts don't proceed in that uncommercial way. I've already shown you the passages in Cattolica 4.6 and 4.7 on the pricing of the MTM and the fee. And there is a further authority which I'll show you, which is from the Council of State, again the highest court in the administrative sector, in which it's clear that the cap and the floor do not need to match. And here, of course, the reason for the disparity was a reflection of the terms of the Bear Stearns swaps. So that deals with 2293. And again, this Council of State case is not cited, nor is Cattolica itself, by the judge in subparagraph 3. What he cites is a decision of the Court of Appeal of Milan, which I'll come on to, and Standard Chartered Bank as well. Then going on to subparagraph 4, the judge again, and it's the same point I've made as the error of principle, treats the novation of the Bear Stearns swap as a separate event and distinct from the other aspects of the restructuring, which we say cannot stand. But it also appears to be suggested in this paragraph that the rolling over of the negative mark-to-market under the Bear Stearns swap was itself a reason why the swaps were speculative. And you see that with the word itself on line 2. And he relies on a decision of the Court of Orvieto and a decision of the Court of Turin. Now, these are not authorities of the highest court and are on the point that your lordship raised with me, but actually the Court of Orvieto is a decision that wasn't even on the merits. It's an interlocutory decision. It's very hard to follow, and it's not clear from the facts of that case why the swap was restructured at all. So it's not persuasive, and it's in any event not representative of the test the judge should have been applying. And stepping back, it can't possibly be the case that a swap is speculative merely because it rolls over a negative MTM. And if it was the case, then the passages in Cattolica would make no sense at all. 2295 is another way of expressing the fact that the value of the cap and the floor were not the same. And you have my submission on that. And 2296 is the significant new risk. And you have my submission as to why there was not a significant new risk, and I'll come on to the cases cited on that. which with respect to the judge are not on point. Paragraph 230 you have read then, in that context it follows. And we then come on to 231 to 232, where the judge then concludes that the cumulative effect of these factors and whatever uncertainties might arise at the fringes of the debate, I am satisfied that an Italian court would clearly find that the transactions were speculative for the purpose of the legal restriction under Italian law. And the speculative elements here refer...
Do you accept that that's the right question?
I don't.
So is the question whether we think the transactions are speculative or whether an Italian court would?
I think that the question is how the highest court in Italy would apply Italian law to the question of whether these transactions were speculative or hedging. The judge has conflated 2 points. One, he says it's an Italian court, and the reason he says that is that he has relied on a raft of first instance or Court of Appeal decisions rather than Supreme Court or Council of State decisions. And he seems to have tried to merge all the different strands of reasoning that he has stepped through, as if, bluntly, there was a consistent system of precedent when there isn't. So that entire process is not a fruitful one, in my respectful submission, but it's also the wrong test.
Well, you said, as I understood your submission a moment ago, that the highest Italian court, which means the Supreme Court, if satisfied that the consob determination tests were satisfied, would conclude that this was hedging and not speculation.
Exactly.
Full stop.
Full stop.
And that what other courts in other bits of Italy may or may not have said in different circumstances is neither here nor there.
Exactly.
Let alone what courts in this country have said.
Exactly.
Because what might amount to speculation here may be a wider concept than in Italy.
Exactly.
Vice versa, I suppose.
Vice versa. So that's point number one, my lord. Secondly, if I'm wrong on the consob determination point, then I would say then the test would be what the Supreme Court would consider to be speculative. And you have the guidance in Cattolica and one other case, the Council of State case as well. And what they show is, far from these elements being regarded as definitively speculative, the reasoning in those cases is to the contrary, because they go on, as I showed you, to look at the characteristics of the MTM in the context of a hedging swap, a negative MTM. And the question is it communicated at the outset to the client? So that would make no sense if a negative MTM at inception, or the mere restructuring, and in Cattolica the swaps were restructured. I'll show you that the judge made that finding, but it's on the face of the report. In Cattolica, the swaps themselves were restructured and were not found to be speculative based on that basis. It was on other factors of authority that the swaps failed. So it's quite clear from Cattolica, so if I'm wrong on consob, I'm also got my second strand, which is that these elements identified wouldn't stack up under the reasoning in Cattolica itself or the Council of State. My third point was that the judge also seems to have, and it's provoked by, I think, your Lordship's question, or my Lord Justice Mayor's question on what do we think in this country, the judge seems to have approached it on that rather mixed basis. He's not even approached it on the test that he posits at paragraph 231, which is an Italian court, because he cites a great deal of English authority as supporting his reasoning, which of course would have no bearing at all on the question that he should have been asking, or even he appears to ask himself in paragraph 231. So you can see that it's gone wrong from this one page of the judgment, in my respectful submission. What I was also going to say to you is that it's worth noting that the speculative elements that the judge refers to in 231 and 232, you see that language in 232, all stem from the payment of the novation fees by the bank and the rolling over of the negative NTM. So it's worth just keeping that in mind as well. And if that's right, you have my submission on why it can't be right, but if the judge's approach were right, again, this whole exercise he appears to have undertaken is completely unnecessary. So can I come on to briefly the Italian and English authorities? And can I first outline, just to make it clear, I think I've already covered this now, the approach the judge should have taken, which is to decide how the highest court in Italy would have decided the case. And just to make it good, the authority for that is the Prato case in the Court of Appeal decision at paragraph 34, which is in the authorities bundle at tab 65. And the second point is that the most relevant authorities, therefore, were those decided by the Supreme Court and the Council of State. And the third point is the decisions of lower courts would be far less relevant, especially if the reasoning was unclear or inconsistent with the principles established by a higher court, or not merits-based decisions. And could I summarise to you, first of all, what principles emerge from the Supreme Court and the Council of State decisions? Secondly, I'm going to summarise the points that are to be derived from the Italian cases the judge looked at. And then very briefly, I will turn to those cases to distinguish them. But in the interest of time, I'm not planning on turning up any of the authorities unless the court wants to see a particular authority, which I'm very happy to do. But I'm conscious that I've got to get some distance this afternoon on all the grounds. But if I can ask the court if there are any authorities that of a particular interest when I explain what they're about, I'm very happy to turn them up. So starting with the Council of State decision, which I think probably is the one I should show you, having said quite a lot about it, and that's in Supplemental Volume 1 at tab 32. The Council of State is the highest court in Italy on public law matters. And it was a dispute between the province of Pisa and the banks relating to the validity of a collar swap that was entered into in connection with a restructuring. And the relevant paragraph, although I don't suggest you try and necessarily navigate through all the facts, is 13.1.1, which shows this. It's at page 301 of the hard copy and 307 of the electronic version. The derivative of it is explained at 13.1.2 on page 303, and the factual context is therefore similar to the factual context in our case. The province argued that the swap violated Article 41 of Law number 448 of 2001 because the swap did not satisfy a test of economic convenience, and the reference you'll note is pages 288 to 289. And one of the points made was that the swap had a negative mark to market at inception in favour of the banks, which resulted in the cap being worth less than the floor, and that's at page 326. And the Council of State rejected the province's arguments. And if we go to page 364 of the bundle, 364.
Are you giving hard copy numbers?
I'm giving hard copy
So we
numbers.
need to add 6.
Do I need to add 6 to this as well? So it's page 370. And it's the last paragraph which starts, as Council for the Province of Pisa also acknowledge. And the point here is, first of all, we can see this from the middle, although these parts were independent and separate from each other, they are nonetheless connected and interlinked. So here you see that all of the swap and the underlying debt has to be considered together for the purposes of economic convenience, such that the swap was not speculative, the consideration of that. And you see that, for this reason, the economic convenience evaluation must be extended to the entire transaction and cannot be limited to the value of the swapped agreements alone. The council then went on to uphold the transactions, notwithstanding that the cap and the floor were not aligned. And you see that at page 371, which is 377, the electronic version.
So the legal test they're applying here is economic convenience,
Yes.
right?
That's under Article 41, where the argument was about implicit costs and did the hidden costs undermine the value of the transaction for the province. And we suggest that 3 points flow from the judgment. First of all, the various highest courts in Italy look at the bond together with the associated derivative in order to assess the overall effectiveness of a restructuring. I accept the court wasn't considering the consob determination here, but it's difficult to see a different approach being taken when assessing whether the derivatives in this case gave rise to new risks for Venice. Secondly, just like the Supreme Court in Cattolica, the decision makes it clear that there is nothing objectionable under Italian law about a negative MTM from inception. And thirdly, and linked to this, there is no reason why the value of the cap should be equal to the value of the floor. And for the court's note, the proposition that there is nothing objectionable about a negative MTM is also supported by the later decision of the Supreme Court, to which the judge does actually refer.
When you talk about negative MTM from inception, is that the inception of the original transaction where it has to be negative because the bank needs to make its profit and cover its costs? Or is that a negative MTM, as in our case, because you are restructuring a product which has already got that negative MTM?
I think both, my lord.
It is it?
I think it's both. And I think Cattolica, because it involved swaps that were restructured, would have certainly allow for the comparable as in our case, because in that case they were in fact restructured.
Yes.
And I think in Cattolica they also discussed the idea that the negative MTM comes from the price and the fee. So I think it would cover both. But the idea is the inherently being out of the money for the province doesn't render the swap speculative. And that's the point.
Yes, I see.
Now, the judge summarises the authorities he relied on in paragraph 212, and then he cross-refers to them in paragraph 229. So it may be easiest, in the interest of time, to take it from 212. Before I tell you about the decisions, can I summarise 5 points that we say arise on the Italian cases properly interpreted? First of all, the highest courts in Italy recognise, time and time again we would say, that the existence of the negative MTM at inception is legitimate and does not automatically render a transaction speculative. And I rely on both the Cattolica case and Council of State. And that's not surprising because otherwise the bank could never make a profit on a swap. Secondly, there is no rational basis, therefore, and certainly no rational basis in any of the authorities we suggest, for concluding that the Supreme Court of Italy would hold that the mere rolling forward of a negative MTM automatically amounts to speculation. No case says that. And so where the judge says itself in the relevant paragraph I showed you, that's just not sustainable. And insofar as he attributed weight to inconsistent first instance authorities, he lost sight of the question he had to ask. Thirdly, the vast majority of the cases on which the judge relied have held that swaps were speculative because there was a significant disparity between the underlying debt and the swap. And those in particular are the cases he cites in 212 little Roman 2. And for example, in taking two of the cases he cites there, payment dates were not matched between the underlying debt and the swap, and that's the Court of Navarra. And the swap related to the company's total indebtedness rather than the relevant particular borrowing, that's the Court of Turin. In some cases, there was no underlying risk at all, and those are the cases in 212 little Roman 1, for example, where the underlying debt was at a fixed rate, and so there was nothing to hedge. So all of those decisions are unsurprising because of the facts of those cases, but they're also uninformative because here there was a high degree of correlation between the risk and the hedge. Those cases there was not. The fourth point is that there is no case which has decided that facts similar to those in this case amount to speculation, or any case that suggests it is necessary to ignore the fact that Venice was already exposed to a negative MTM under a pre-existing swap. And fifth, nothing in Cattolica compelled the judge to find that these swaps were speculative. And on the contrary, his findings are contrary to the statements made and findings made in Cattolica. And it couldn't be clearer because on the face of the judge's own judgment at paragraph 212, he acknowledges that Cattolica didn't set the very test he then seeks to apply, which with respect to the judge, he appears to have not invented for himself, but certainly progressed himself is possibly the best way to put it. So just quickly then, going through 212. Little 1, as I said, these decisions, Turin and Lucera and Florence, they are not Supreme Court decisions. They are not on point because there was an underlying risk to hedge in this case. There was not an underlying risk there. In 212 little 2, the decisions again, and this is of Rome, Navarra and Turin, they're about the need for high correlation, the judge says, in the end of that paragraph. But in our case, that is what we had. So again, these decisions don't take it further. And if we just cross-refer then to 229 little 2, you see these are the decisions that the judge imports into the mismatch. But we know, as I've already addressed to you, that the mismatch he perceives are the cap and the floor, which is not a mismatch, and the facts of those cases are different.
The first one, 212 Rome 2, the Court of Cassation, is that a different court to the Supreme Court? Because normally the Cassation Court is the highest court.
Yes, that one is the Supreme Court.
That is the Supreme
yes.
Court, yeah.
And I think that is the one at tab 35 of the supplemental bundle.
Right.
And in that case, it was a dispute between a private company and a bank, and the swap had been renegotiated a number of times. And the company argued that the swap was speculative and didn't have a valid purpose. And the reason that case it succeeded was because the swaps related to the company's total indebtedness, which had different commencement dates, maturities and yields. So there was no correlation. And that's a long way from the facts of our case. And in that case, if I can just show it to you, the Supreme Court held that the Court of Appeal had erred because it failed to apply the consult test.
Yeah.
So if I can just show you that one, it's tab 35. And if we go to page 400, paragraph 7, you see the reference to the consult determination. You read the whole of paragraph 7, please. So you see the test that's being applied is the consult determination. And then in paragraph 8, you see that there was not a high degree of correlation because, and it's the second paragraph down on page 401, 407 in the electronic, they do not appear to be linked to the individual and specific underlying transactions with hedging commensurate to the risk inherent in individual debts. Rather, they appear to be based on a total indebtedness comprised of a number of separate debts with different commencement dates, maturities, and yields. And that's not the facts in our case. And there's no suggestion here, again, that renegotiating a swap meant it was automatically speculative.
Sorry, this did involve renegotiated contract, did it?
We'll check you, my lady.
It looks like it did.
It looks like it did. Just, I'll see if I can find it in the report. Yes, page 397. The swaps had been renegotiated a number of times. You can see replaced by in the head note. So if we then go back to 212(3), this was a case about converting fixed rate borrowing to a variable rate, which isn't relevant. And to be fair to the judge, these cases, Lazio and Venice, were not cited in his paragraph 229, even though he summarised it here. So he doesn't appear to have relied on it. You then go to little 4, which is the Court of Appeal in Milan. Now, this case, I accept, is a case that it is against me, but it's a Court of Appeal decision, and it's very hard to understand the facts from it. The local authority sought to invalidate a collar swap on the basis that it was inconsistent with Article 41 and the MEF circular, and the main submission was that the value of the cap exceeded the value of the floor. And it's hard to discern the extent of that from the facts, but the negative MTM was around 500 million, it looks like. Sorry, 500,000. It would be very surprising if the cap and floor needed to be completely aligned for all the reasons I said, and Cattolica doesn't appear to suggest that. And in the end, the case didn't, in fact, have to be decided on that point because the MEF circular is a mandatory rule of Italian law, and the judge held that the rules are inapplicable. here. So the reasoning in this case is of no relevance to the speculation point. I accept, though, that the case did suggest that a derivative with a mismatch was speculative, but the reasoning is suspect because it's not clear why and inconsistent with Cattolica. And although the court quotes from Cattolica, the reasoning is flatly inconsistent with it, and similarly the Council of State. And there is no suggestion on the facts of the Milan case that the disparity in the value of the cap and the floor arose as a result of a pre-existing transaction, which was not speculative. So I can take the court through that decision if that would be helpful, or wait to see if my learned friend relies on it and responds. But my submissions are: one, it's a decision that's hard to understand because it's inconsistent with Cattolica, even though it quotes it. Two, it's not of the Supreme Court, so it's not necessary. And three, the judge applied it in 229 subparagraph 3 of his judgment, but without any critical analysis or seeking to reconcile it with the two Supreme Court decisions. I'm calling the Council of State the two highest court decisions, Cattolica and Council of State, even though it was inconsistent. The next case which I wanted to deal with similarly is the Court of Orvieto in subparagraph 5, which is cited by the judge as well in his little 4 of 229. And that was the restructuring itself points to speculation. And again, this case, first instance interlocutory decision, the facts of which are not clear. And it's very difficult to understand when you read it why the mere fact that the negative MTM is rolled over could render a transaction speculative. And it doesn't suggest, it's not suggestive of a definitive decision. It also predates Cattolica. And it also appears to fundamentally misunderstand the nature of a negative MTM, treating it as an accrued loss when it isn't. So again, those two cases I can see provide some support for the propositions the judge thought he was making, but they're not sound decisions on their facts, and it matters not because they're not the relevant authority, and the judge never acknowledged that or tried to rationalise them with the authorities he should have been applying. And then I think the final one I need to cover is the Turin case. And if I can show you that, that's in Supplemental Volume 2, tab 41. And this was a dispute between a private company and a bank relating to the validity of two derivatives where the swaps were held to be invalid. And that was because the swap failed to disclose the negative MTM. And the second reason was that there was no high degree of correlation proven. And that was because the swap related to the company's total indebtedness. And if we look at 502 of the report, 507, 508, the electronic version, you see the very bottom paragraph shows the consob test being applied. And the key elements of alignment that the court considers are relevant, you see in the middle of the page, the technical financial high correlation also concerns the main supporting elements of the hedging instrument. And these are all present in our case, but were not in this case.
So I'm not picking up where you're reading from.
I'm reading from, my lord, it's about 4 paragraphs down, the technical financial.
On which page?
page 503.
503.
So 502 shows the consub test in the bottom paragraph, and the passage runs on, my lord, to say what is high correlation, basically, over the page on 503 or 509 for electronic. And these are the elements that are identified by the court. And then if we go on to 507, in the middle of that,
The passage immediately after what you read on 503 seems to make good your point that you only need a high and not a perfect correlation.
exactly right. And then 507, which is 513 electronically, there's a second paragraph starting renegotiation. I don't know if you can see that. Sorry, these paragraphs aren't numbered easily. And that paragraph says no more than renegotiation can cause a swap to be speculative to the extent the correlation test is no longer satisfied. It depends on the facts. So what we would suggest is merely renegotiating a swap by rolling forward a negative MTM does not mean that the high degree of correlation is necessarily lost. And on the facts of this case, the correlation test failed not because of the renegotiation, which makes my point, but because there was a mismatch in the elements identified. And the reason that's relevant is that this is the authority relied on, as well as the Orvieto case, in little 4 of 229 as the authority for merely rolling over amounts to speculation, but it simply doesn't say that. And then the final decision of the Supreme Court in little 7 of 212, 2 points on this. This case doesn't assist because the Supreme Court was not asked whether and in what circumstances an absence of alignment would render the transaction speculative. And the last sentence of this paragraph makes the mistake of treating this as an off-market swap to cover a cost, and I've made my submissions on that. And we then go to...
And I find it quite easy to accept your submission that these cases, some of them are difficult to understand, but presumably the judge had a lot of exposition of them from the various experts. So although he refers to them here, is that not right?
I wasn't at the trial, I'm afraid, my lord, but my understanding from nobody on my team was not there, so it may be easier for those who were. But our understanding from the transcripts is that there was not, and the judge, a lot of this exercise was undertaken by the judge himself. That's. I'm sure Mr. Cox can address you further on that, but that's certainly from the reading of the transcripts what we've ascertained.
Yes, all right, thank you.
And again, with no criticism of the judge, these cases aren't easy to understand, although I've worked through them and I do understand them. It's simply I don't have the hours it would take to go through each case to make good all the points I've made, but I can give you the references, and of course if it would help the court, we can produce a short summary showing you each of the cases and what they said and where.
That would probably be quite helpful if that's not too much of a burden.
Certainly can do that. I already have that, if time had been permitting. But the point is that there's no doubt that one or two of the authorities, Milan and Orvieto, might be said on their face to provide some support for the propositions the judge was identifying. But the problem with those cases are the facts were different in certainly Milan, that case. Secondly, they're not of the right level of authority to be compelling. Thirdly, they're inconsistent with the higher authorities that I have shown you. And fourthly and crucially, the judge didn't actually engage in the exercise of trying to reconcile or critically analyse those authorities in the way that I am doing now, to see that they don't support his propositions or that they are inconsistent with Cattolica itself. And the reason I think he was in that position was that he had formed the view, perhaps in the way because of the submissions made, that the right approach was to focus on the rolling over of the MTM, to treat that feature as inherently speculative. And then he seems to have listed out bits of authorities that seem to suggest that that conclusion was right, but missing the main event in my respectful submission, which is Cattolica made it plain it wasn't right. But it does appear to be an exercise, as far as we're aware. I will of course be corrected on it as I was not there, but from what we can see, it doesn't seem to be the case that he was taken through each of these authorities in the way that I think my Lord Justice Males is contemplating.
Yes, right.
And in paragraph 213, the judge does mention Cattolica, and the short point here is that the swap was not held to be speculative in Cattolica. So if the mere fact that having been it having been a renegotiated swap by absorbing an MTM, negative MTM, was sufficient to render it speculative, the court in Cattolica would have said so. That then leaves the judge's analysis of English case law. Now, the court has my submissions on this point. It's not entirely clear why English case law really came into this at all. But insofar as they did, and the judge does sort of express some scepticism, but then did cite them, the Vestia case doesn't take the matters any further. I'll come back to that in a different context. The UBS case, as my Lord Justice Males will know, doesn't seem to be on point because it's so far away from the facts. It's KWL became exposed to a whole new risk of default by other people, which is a very long way from the facts. And the Ceylon Petroleum case, we're going to look at in the context of capacity, but it doesn't actually provide any support for the judge's distinction, because the Court of Appeal in this jurisdiction considered that the distinction between hedging and speculation was a false question precisely because it was so difficult to apply, particularly in the context of capacity. And I'll show you the relevant passages, if I may, under ground 3, just to make that point. So, my Lord, those are my submissions on ground 1. And in a nutshell, I think you have them, which is Cattolica didn't set the test for speculation, rather the judge endeavoured to find his own test. If he had applied any test for speculation, he should have applied the consob test, which these transactions met. Even if I'm wrong on that, the transactions were not speculative for the reasons identified by the judge as a matter of Italian authority of the highest court, and it would make, fourthly, it would make no sense if they were, because it would be impossible for banks to enter into any swap or provinces to renegotiate any swap if the judge's conclusions are right. Can I turn then to ground 2, please? So this concerns the related question of whether the transactions infringed Article 1196 of the Constitution. And we suggest it's a closely related question. It all turns on the proper construction of one sentence in Article 1196, which we've looked at, but just to remind you, is in supplemental volume 22, sorry, volume 1, tab 22, in the hard copy, page 168, and in electronic, it will be 174. The judge held in summary that the transactions violated Article 1196 because the novation fees constituted upfront payments and that those payments were not made for the purpose of financing investment. So those were the two reasoning, and the relevant paragraphs are paragraphs 259 and 268. And that gives rise to two questions. Were the novation fees properly to be analysed as upfront payments? And secondly, is an upfront payment made in connection with a hedging swap impermissible? Now, I've already shown the court this morning the test for an upfront payment in the Cattolica decision, and the experts below agreed that this was the right test. That was in section 10 of Cattolica. And if you could just see the joint statement of the experts below, it's volume 1 of the supplemental bundle, tab 21. And it's page 166 of the hard copy and 172 of the electronic. And it's paragraph 210. So you can see it's to rebalance the financial situation in non-par swaps. And it's an amount of money paid by one party to another, i.e. the party accepting the less favourable terms. Now, the short point we make on this ground is that there was no payment by the banks to Venice to rebalance the transaction. The novation fees were paid to Bear Stearns, as you saw in the novation confirmation, and not Venice. And secondly, the negative mark to market was rolled over, it wasn't balanced out. And the relevant reasoning in the judgment, therefore, we say is wrong, and that's at paragraph 261 of the judgment. And the starting point is the judge applied Cattolica, the rationale in Cattolica over rebalancing, but it wasn't applicable to this transaction because, as the judge himself acknowledged in 261 subparagraph 2, there was no rebalancing, and that ought to have been the end of the debate. The second point is that the judge misunderstood the bank's expert evidence on this point. His clear evidence in his reports was that the novation fees did not amount to upfront payments. And his opinion is accurately summarised in paragraph 2.12 of the joint statement we just looked at, and that's in supplemental bundle 1, tab 21, page 166 or 172 of the electronic bundle. And it's 2112. And the judge appears to think that Professor Gentili made a concession in cross-examination on this point, but he didn't. And you can see that if you look at supplemental volume 2, tab 62, and it's page 655 in the hard copy and 661 in the electronic version. And you have to read from line 22. I'm afraid you have to read from line 22 on this page to over the page, line 22. And in this scenario, A is the party in Venice's position, B is the party in Bear Stearns' position, and C is the party in the position of the banks. And the professor clearly accepted that there could be a delegated payment if Venice was otherwise entitled to receive the payment, but instead requested somebody else receive it. But here, Venice was never entitled to the novation fees. And the professor's evidence provided no support for the judge's reasoning.
What he's saying here, isn't he? Well, it's one thing if you had a situation where the money was owed to Venice in the first place,
Exactly.
but they ask the bank to pay it to somebody else to whom they owe debt. You can see how that
Exactly.
you couldn't escape the conclusion that that was an upfront payment.
That's right.
Because what was done at their request. But he's making the point that the situation here
It's different.
is a different one.
Exactly.
And this was never going to be entitled to
Exactly.
be paid anything on this basis.
Exactly. And the judge, though, seems to have treated his evidence, if you look at 261 Roman 3 of the judgment, as something different. I accept Mr Cox's argument, the fact that the payment in question moves from the bank to Bear Stearns rather than through Venice does not change the analysis. Professor Gentili accepted in cross-examination that is essentially what happened. There's just no scope for that looking at the novation agreements. It's not what happened. And then the third point, my lord, on these paragraphs is the judge didn't place significant weight on how the banks described the transactions internally. And they, of course he didn't, because they made no reference to the legal test under Cattolica, which wasn't decided until 2020. They're not relevant to this. Now, in my learned friend's skeleton at paragraph 63A, he seeks to support the judge's reasoning by reference to the evidence of Professor Alibrandi, Venice's expert. And it is said by my learned friend that the judge must have had this in mind, even though he didn't say so in the judgment. The starting point is, of course, the judge took into account, I'm sure, all evidence, but it's clear he didn't rely on Professor Alibrandi's evidence for two reasons. First of all, the judge is at pains at all times to state throughout this judgment what he relied on, so it would be a surprising omission. But secondly, Professor Alibrandi's evidence is actually inconsistent with the judge's analysis. And you can see that because, and I can simply give you the reference to it, it's her third report at Supplemental Bundle Volume 1, Tab 18, page 141 hard copy, 147 electronic, and it's paragraphs 20 to 22. And her view is premised on it being possible to infer a mandate from Venice for the banks to make payments on their behalf. So it's suggesting that it's in some way the banks are acting as Venice's agent under a form of mandate.
Yeah.
Well, A, that didn't happen, and B, that's inconsistent with the judge's analysis. So it takes matters no further. So my lord, that is the main ground on which we say ground 2 should succeed. These clearly were not upfront payments as defined by the experts and the Supreme Court in Cattolica for the two reasons I've given you. And you can see the fundamental misunderstanding in 261 sub-Roman 3 that led the judge to an erroneous conclusion. If, however, you're against me on that point, we say that in any case, if this wasn't upfront, it was not for an impermissible purpose. And the reason for that is based on the same error of principle that the judge made in relation to the speculation issue. And you see that the judge himself drew a link at paragraph 268 of the judgment, between his conclusion that the transactions were speculative and his finding as to the impermissibility for the purposes of Article 1196.
Yeah.
And we say it's the same point. And just to add colour to this, we say it's obvious that if a swap is found to be a hedge, it doesn't create new risks for the local authority because its purpose is to manage the risk arising from the underlying debt. So if you're with me on the speculation point, which to get to this ground you have to be, then it follows that you should be with me on the point that it's not an impermissible purpose because it's a hedging purpose. And the point is supported by Venice's own expert in cross-examination. If I can give you the reference, it's Supplemental Volume 2, tab 55, page 688, line 10 to page 690, line 21. And that would be 694 to 696 in the electronic version. And what you see in this passage is that Venice's expert, Professor Domicelli, was clearly of the view that a hedging derivative did not infringe Article 1196 of the Constitution because it did not increase the risk of underlying debt. Now, my learned friend says, well, his evidence irrelevant because the judge made a different finding. But the point is that his own expert saw the sense in how can a hedging derivative be impermissible when the underlying debt was permissible. And then finally, my learned friend contends that we do not appeal the judge's findings in paragraph 268, but that's wrong because we identify it in our grounds of appeal and our skeleton. And you can see that in our skeleton, paragraph 49, and our grounds of appeal, paragraph 3.
Sorry, paragraph
3. So for those reasons, we say that the swaps were not invalid under Article 1196 because they were not upfront payments, and even if they were permissible. So if that's right, then that's the end of my appeal because I only need to succeed on grounds 1 and 2 to succeed. Because then the premise for the judge's finding that the transactions were void falls away and should be set aside, and then the court would grant declaratory relief confirming the validity of the transactions and order Venice to pay the amounts due under the transactions, and all the remaining grounds of appeal and Venice's appeal fall away if I'm right on grounds 1 and 2. I think sadly for the court though, I have to carry on grounds 3 to 5. So may I turn next then to capacity, please. So it follows that this ground of appeal only arises if you uphold the judge's conclusion that the swaps contravened one or other of the rules identified in Cattolica, speculation or upfront. And then on that premise, the question arises whether the judge was correct to analyse those rules as restrictions on Venice's capacity as a matter of English conflict of laws. And we submit that he was wrong to do so. And the reason is that the judge should have held that the rules identified in Cattolica, namely speculation and upfront payments, were mandatory rules of Italian law and not restrictions on Venice's capacity. And if the judge had reached that conclusion, he would have held that the rules in Cattolica were inapplicable because he himself found, and this finding isn't challenged by Venice, that Article 3.3 of the Rome Convention was not engaged. Can I start with that introduction of identifying the legal principles which govern this issue? So the starting point is that there is a distinction, as the court will know, between ultra vires and illegality. And as a matter of English law, the distinction is between the rule which restricts the capacity of a legal person to act in a particular way, as opposed to a rule which prohibits a legal person from exercising their capacity in a particular way. And the most helpful discussion of this is in the Rampersad case, a recent judgment of Lord Leggatt, which I'm going to come on to and show you. And the distinction between the two rules assumes even greater importance where there's a conflict of law, because foreign rules which prohibit a legal person acting in a particular way are rarely applicable for the purposes of assessing the validity of an English contract. And in the present case, it's common ground that the applicability of such foreign law rules was governed by Article 3.3 of the Rome Convention. So it's common ground that there's the finding is now made.
But it goes back to Raleigh Brothers, doesn't it? I mean, it's
It
one of
does.
the points that's made by Lord Justice Akins in Haugeston.
Exactly.
So if the contract has to be performed in the foreign jurisdiction, that's one thing.
Yeah.
But if it doesn't, then normally the court, foreign illegality is not.
Exactly. And the Haggerson case, which we accept is binding, if this goes further, then that's maybe looked at again. But the Haggerson case, it's all about whether the relevant rule that we're going to look at is the source of the power. And that's the ultimate test. And that's very clear from the new judgment I'm going to show you of Lord Leggatt, which is very helpful on showing the distinction I'm making. And so with foreign law, under Article 3.3 of the Rome Convention, a foreign mandatory rule will apply where all the other elements relevant to the situation at the time of the choice are connected with one country only. And in the Prato case, the Court of Appeal interpreted Article 3.3 narrowly so that they held it would not apply the moment that an international element comes into the picture. And the reference for that is Authorities Bundle tab 65, Prato decision of the Court of Appeal, paragraph 137. In this case, the judge found at paragraph 341, Mr Justice Foxton, and that's at page 286 of the judgment, or that it was clear beyond argument that Article 3.3 doesn't apply because of the international element of the transaction. So it follows that if the rules identified in Cattolica are properly to be characterised as mandatory rules of Italian law, then they do not apply and the swaps take effect in accordance with their terms. And you can see why Article 3.3 must be applied narrowly, otherwise it would undermine the parties' express choice of law. Now, under English law, the question is as to whether Venice had capacity to enter into the transaction is, of course, approached differently. And the leading authority is the Haggerson case, my Lord Justice Flo has just referred to. And you can see how the judge below dealt with it at paragraph 108 of his judgment. And that's at page 204. So the characterisation is a question of English law, and the quote I can come back to, but paragraph 109 is worth reading. So
Is this right, that it's a matter of Italian law to, you apply Italian law to ascertain whether the rule is a limit on the powers or a prohibition? But once you've answered that question, then English law tells you that if it's a limit on the powers, it goes to capacity.
exactly.
If it's a prohibition, it doesn't.
Exactly. And 2 points flow from this is that whether the particular foreign rule defines a substantive power of the entity, and it's not so much international, but it's to be ascertained from an internationalist perspective by reference to all relevant sources of power. So it can't be just the English law approach, I think is perhaps the way it's put in Haggersund. And then if we could please go to 112. Sorry, 112, 112. This is what the judge looked at.
Yeah.
If I could ask you to read this paragraph. So the first point is that there are 4 points to make about this section. The first point is the judge doesn't indicate that any of these factors would be determinative by themselves. The second point is that the weight to be given to the first 2 factors is, in my submission, limited, because it's far from unusual for a law to prohibit certain conduct, but only for certain types of entity or people, depending on characteristics. And likewise, it's entirely possible for a statute to prohibit one person from entering into a type of contract that another person can lawfully enter into. The third point is that the judges...
I must confess, I found point 1 in particular quite difficult to follow, really.
Exactly, my lord.
I don't see how it really helps to answer the question, because what was really focusing on is the nature of the statute,
Exactly.
whether it's imposing a prohibition or something which is effectively the equivalent of ultra vires.
Exactly. That's why I say the first 2 points I don't think advance matters. Points 3 and 4 go together, and exactly, my lord, the point I was going to make was the critical point is that the statute must be both the legal source of the power and contain a qualification on that power. And it's the legal source of the power that's very important. And Haggersund is to be analysed in that way. My fourth point is that it's important that these principles are applied restrictively so as not to undermine the restrictive approach taken to the application of mandatory rules. Otherwise, we open up the risk that the security of English law contracts will be undermined by allowing mandatory rules to take effect by the back door, notwithstanding what's the limit that's been placed on them, in the guise of allowing a restriction on the legal entity's power. So one has to have that in mind.
And I suggested to you a moment ago, and you agree, that when you're asking whether something is a restriction on powers or a prohibition, you're looking at what the foreign law, the Italian law, has to say about that. But this seems to be an exercise which a judge would do applying what look like English principles. Now it may be that, I'm not quite sure where the judge gets these from, but they look as if he's applying his own analysis as an English lawyer there. is that the right approach, or should he simply be asking the Italian experts to tell him whether, for example, infringement of Article 1196 is something that goes to the local authority's powers, or whether it's a prohibition?
I think the latter, my lord, and there was a lot of expert evidence on this.
Yes.
And
Well, one of them,
I'm being told I've got this wrong, so let me come back. I think there's cross purposes going on. There's a great deal of outrage that you don't ask an Italian lawyer, is it capacitive? I don't think that's what you're asking. I think what you're...
No, I'm asking
exactly.
Italian law.
You're asking, what's the source of the power? What's the effect of Article 1196 under Italian law? And does it confer the relevant power as a matter of Italian law? You then look at it from an English perspective then as well to see, is that then, in the light of that answer, is that capacity?
Yes, exactly as I
exactly.
sought to put to you before.
Yeah. Well, I
you
agree.
agree?
I don't see at the moment shouted out from behind, but I agree with you, Lordship. And there was a lot of Italian law evidence on the purpose of Article 1196 and whether it conferred, what it conferred and where the power came from. And cutting to the chase.
In which case, unless this is a synopsis of what the Italian lawyers were saying, which I don't think it is,
No,
then
that's wrong.
It's on your submission irrelevant.
That's right. That's right. And I was going to show you then 271
judgment.
of the judgment. So here, in paragraph 270, the judge sets off on his analysis of Article 1196 and looks at the evidence of the professor in 272, Professor Torchia.
Well, at 270, what he's doing is summarising his previous conclusion.
Exactly.
That as a matter of Italian law, the restriction in Article 1196 was the restriction on the substantive power to enter into the transactions and not a prohibition. And if that's right, the English law consequences follow really on the basis of Hogerson and the majority.
Exactly, that's his reasoning. But looking at 271, the first 2 points, as I've said, don't take the matter very far. It's the third point, which is important, and that's where the judge makes his analogy with Hagersund, because he says Article 119 grants the power and restricts the power. Now, in my submission, that's where he fell into error, because the evidence before him from the Italian experts showed that that was not right, and that Article 1196 did not confer the power to borrow at all. And that is to be contrasted with Hagersund, where the local authorities derived their capacity from Article 50 of the Norwegian Act. And that's why derived their power from it. That is why we say the judge fell into error. So can I show you Hagersund now, which is in the Court of Appeal decision in the authorities bundle at tab 49. And that is in volume 7, the hard copy. And it's page 2681 in the hard copy and 2687 in the electronic version. And the dispute was between a local authority in Norway and a bank about the validity of swaps. And Mr Justice Tomlinson at first instance held that the swaps contravened Article 50 of the relevant Local Government Act, and that meant the swaps were beyond the capacity of the local authority. And the judge reached the conclusion, notwithstanding that under Norwegian law the swaps would have been voidable rather than void, and the bank's appeal was dismissed, but with a fairly powerful dissent from Lord Justice Etherton, who took issue with the idea that if the contracts were voidable under Norwegian law and could be enforced in certain circumstances if the third party acted in good faith, he didn't understand how they could be treated as void. So that was the dissent. Now, the judgment of Lord Justice Aikins was seen quoted by the judge, paragraphs 47 and 48. That's the broad internationalist perspective. And then if we go please to paragraph 55, we see how the court applied the test to the expert evidence. So the 1992 Act provides the municipality with the power to take up loans, but it also restricts and regulates the purposes for which they may do so. So the correct analysis we suggest of this decision is that the local authorities didn't rely on their general capacity when entering into loans, because the source of their power was Section 50 of the 1992 Act alone. And that same provision placed limits on how the substantive power could be exercised. And the legislation is set out in this report if you want to see it. It's at page 2728 of the hard copy and 2734 of the electronic version. And the use of the word may doesn't suggest that it's anything other than a proper, it has to be looked at, I should say, in the context of a construction of the statute. And the wording here was read to impose restrictions in accordance with the terms of the relevant section. And the context of Section 50 is an important point and is explained by the trial judge in his judgment. And just for your Lordship's reference, I won't turn that up, but it's in the authorities bundle, tab 46, paragraph 108, that it was common ground before the trial judge that Section 50 was a rule regarding the powers of local authorities. And if you, for your note, look at paragraphs 111 to 113 of Mr Justice Tomlinson's decision, you say those paragraphs make it plain that the power to borrow was conferred by Section 50 and it was not derived from the general capacity of the local authorities. So the upshot is the power to borrow was conferred by the very provision which also defined the limits of that power. Now, if we can contrast the Haggerson case with the recent decision of the Privy Council in Rampasand, that, I think, makes the point clearer, and that's at tab 84 of the authorities bundle, volume 12.
So that one was really common ground at first instance.
That it was common ground that
The local authority powers were given by the Act, and that the Act imposed restrictions on.
it was common ground, it was a rule regarding the powers of the local authorities. And then Rampersad is tab 84 of volume 12, and that's page 4947 in the hard copy and 4953 in electronic. And it's and this was a case about the validity of a secured loan. And a credit union borrowed money in excess of the maximum amount that was permitted under statute. And the rule is set out in paragraph 2. And you see the word shall. The liquidator of the credit union said this meant the contract was void, either because it was ultra vires or because it was illegal. And that would have left the lender to prove in the liquidation as an unsecured creditor. And if we go to paragraph 23 of the report, please. This clearly states the distinction between ultra vires and illegality. If we then go, please, to paragraph 58, and in the hard copy that's at page 4967 or 4973 electronically. So here the judge, Lord Legate, decides that the rule that we've just looked at in paragraph 2 was a prohibition and not a restriction on capacity. And he's focusing principally on the words of the statute in their proper context. And if we could also read paragraph 60, where the judge emphasises that the Act was not intended to be a power conferring or limiting statute. It was to set down a regime of rules with which the societies were obliged to comply. And in that context, may and shall are more likely to be prohibitions than limits on the capacity.
Mm.
And in paragraph 66, he goes on to say that the Act sets out sanctions for a violation of the rules.
He reaches that conclusion, with which the minority disagree,
That's right.
because of what he refers to at 57 as a more flexible approach.
Yes.
That's to say there should be a presumption that a rule operates as a prohibition rather than as a restriction on powers. Now, presumably, that is a presumption which operates as a matter of Trinidad and Tobago and probably also of English law. It doesn't help you, does it, in determining whether as a matter of Italian law, Article 119 is the one thing or the other, because, as you've submitted, that's a question of Italian law.
Insofar as it's a principle of Tobago law, it certainly doesn't help me. But insofar as it's an approach on an internationalist basis of the distinction between illegality and ultra vires, then I can rely on it. I think that's the point I was.
It would be a bit hard to do that, wouldn't it, without adducing some evidence in the court below that Italy adopts an internationalist approach.
But also Italy doesn't know the doctrine of ultra vires.
I
That
don't.
was the problem in Haugesund, or one of the problems in Haugesund.
I don't press the point except to say I think it was really my last of my 4 points, which is that you, in order to be consistent with Article 3.3, one does have to have in mind not seeing ultra vires unless one's absolutely sure.
But
And that's as far as I can
what's
put
been
that point.
evidence from the experts
Yes.
before the judge as to whether, as a matter of Italian law, this was conferring the power and restriction on the power on the one hand,
There was.
or
And I'm going to-
prohibition on the other.
I'm going to show you, the bank's expert said that it was a matter, entering into derivatives was a matter of general power, civil capacity, and was not conferred by Article 1196. That was the clear evidence of the bank.
And what about the
That was
cases expert?
not the evidence of the other side, but I'll come on to show it to you. So can we just start with the judge's judgment, which is 272 on this, where he records Professor Torchia's evidence, that's the bank's expert, that Articles 1194 and 6 did not restrict the capacity. And she said that local authorities have general contractual capacity.
Where are we? 272.
272 of the judge's judgment. Now, importantly, the judge records that Venice did not take issue with any of those statements under Italian law, but nevertheless argued that it was to be classified under Haggersund and the approach there as a restriction on capacity. And can I just unpick this just so that we're absolutely clear what wasn't challenged? Can we go to Supplemental Volume 1, tab 17, please? And it's question 1.1 to 1.8 on page 127 of the hard copy and 133 of the electronic version. And this is Professor Torchia's third report.
So which paragraph are you looking at?
The question is set out as to capacity in 15A on the first page,
Yeah,
and then
okay.
she says the answer requires a few preliminary remarks, and she talks about the fact that public bodies have a general public law and civil law capacity and can freely contract 1.4, and that civil law capacity gives public bodies a general freedom to enter into contracts. That's paragraph 1.6. And then paragraph 1.8, that Italian public bodies can legitimately enter into transactions and contracts. So her evidence was local authorities derive civil capacity to enter into swap contracts from the Italian Civil Code. Secondly, there's no doctrine of ultra vires in Italian law. And thirdly, Italian law restricts what legal persons can do with that capacity to contract through specific prohibitions. And there was no expert evidence below which said that Article 1196 was the source of the local authority's power to borrow. So we suggest on that basis, it's clear Article 1196 did not confer the power to borrow. And the purpose of it was addressed by Professor Torchia in her first report, which is in tab 8 of the same supplementary bundle. paragraph 12.1 to 12.8. So 2 points from this passage. First, the purpose of Article 1196 as a whole is to regulate the financial authority of the regions. And secondly, it sets down an imperative constitutional norm. And if you look at the article, it's set out, the text of it is helpfully set out on the same page at 12.4. So the word may, we say in this context, given that my point about the distinction with section 50 being the conferring provision and the use of may was interpreted in that context. Here, this isn't the conferring, this isn't the source of the power to enter into contracts. This is a prohibiting article, limiting that ability to enter into contracts on the basis that they may do so, and indebtedness, of course, is a defined term, only on certain terms. So we say this is to be, along the lines of Rampersad, clearly to be interpreted as a prohibition and not a restriction on the local authority's power. And we say it's no different from the various rules that Lord Leggatt looked at in Rampersad. But it is different from Haggerson, where it was the source of the power in the entirety of the rule. And there are a number of important points that we say reinforce that submission. So first of all, the sanction for breach of Article 1196 is set out by statute. And if you can go in the same bundle, please, to tab 24. And here, the words violation of Article 119 and the imposition of a penalty, as you can see those words, suggest that Article 119 is a mandatory law. But if it were a restriction on capacity, there would be no need to enact this legislation because the transaction would be already void. And again, that's another analogy with the Rampersad case. Secondly, the definition of speculation, as you have seen from the submissions that have taken a large part of today, is far too uncertain to constitute a restriction on capacity. You've seen the judge's approach to the question of whether a swap is speculative, with the number of indicia, some of which required an economic analysis of the transactions, some of which can only be carried out after the event. So it would be incredibly difficult, if not impossible, confidently to predict at the time at which the transaction was made, whether it would fall on the right side of the line. And so from an English perspective, making due allowance for the internationalist perspective which Haggerson requires, it's implausible to suggest that Venice's substantive powers are to be defined by reference to criteria that are uncertain. And that point was made very clearly in the Ceylon petroleum case, And could I just show you that now, because I promised I would come back to it. It's in the authorities bundle at tab 51, please. And that's in volume 7. So the case was concerned with a Sri Lankan petroleum company which had entered into various derivatives linked to the price of oil. And the company argued that the transactions were beyond their capacity insofar as they were speculative. And that led to some debate before the judge. And if you could please look at paragraph 22. This is the Court of Appeal decision. Judgment of Lord Justice Moore-Bick. And then the third point is that Article 1196 is similarly uncertain in its application, and there are two levels of uncertainty. First of all, based on Catholica, Article 1196 only applies to certain types of swap. So it's only speculative swaps which constitute indebtedness, or non-speculative swaps, sorry, which constitute indebtedness, such as swaps with an upfront. So it follows that Article 1196 cannot be a rule which confers the power to enter into swaps generally. So, put another way, if the swap doesn't come in within Article 1196, the local authority must be relying on its general civil capacity. The fact that only certain types of swap are caught by Article 119 suggests it's not a power conferring rule. It's a rule which prohibits local authorities from entering into certain types of swap for an illegitimate purpose. The second layer of uncertainty is that even if the swap is caught by Article 1196, it's only impermissible if entered into for the wrong purpose. And this requires careful consideration of the subjective intentions of the authority when entering into the swap, and whether the swap has been used for its intended purpose. And you see this point explained by Professor Gentili in his report, and that's in Supplemental Bundle Volume 1, tab 14.
Yeah.
And if you could look at, it's page 112 of the hard copy, page 118 of the electronic bundle. And it's paragraphs 2.55 to 2.57. And this evidence wasn't challenged or contradicted by Venice's experts, and it wasn't addressed by the judge in the judgment. And the point being made here is flatly inconsistent with Article 1196 constituting a limit on Venice's capacity. And of course, as the judge found at paragraph 210, the question of whether Venice had capacity to enter into the transactions must be tested at the point when Venice purported to exercise that power. So if when the local authority entered into the contract, they intended to use the funds for a particular purpose, but subsequently changed their mind and did use them for a different purpose, the capacity which they had when they entered into the contract, we say, can't vanish into thin air. Now, Venice's answer to this point is at paragraph 83 of their skeleton. And it seems to be to say that Article 1196 has a dual function. It deals with capacity at the time of contracting, and then it imposes a prohibition, they say, on subsequently changing your mind. But we say you just can't read that into the article. And we don't know what words they rely on to advance that submission. So, my lord, that is the end of ground 3. We suggest that the judge was wrong in finding that Venice lacked capacity, and that what he should have done is found that, as in Rampasand, Article 1196 was a prohibition on entering into certain types of derivative transactions as opposed to conferring the power to enter into derivative contracts. And in that way, Haggersund was distinguishable, and Venice did not lack capacity to enter into the transactions. That then takes me finally for today onto ground 4. And in the time, I think I should outline the nature of the ground, which is an interplay with the other 3, and then develop it tomorrow. So this is the ground that I fully accept we need permission to argue, and I'll make that application within the course of my submissions, if I may, having developed it. It's an argument that obviously occurred at some level to the judge, and you see that in his judgment, but it wasn't argued below. It is, however, a point of pure law, and the suggestion in my learned friend's skeleton, which I'm not sure is pursued with terrible vigour, that some different evidence would have been required, it is not right, and I will engage with that. There is no further evidence needed to argue this point. It's certainly the way it's being argued. And what it is it concerns, as your Lordship knows, the retrospective effect of Cattolica as a matter of English law. And there are 4 points to make on this ground. The first is on the judge's findings, and of course this point only arises on the basis that you accept that the judge was right to find that the swaps were void and that Venice lacked capacity. And on this basis, the judge held that Cattolica was both unforeseeable and had retrospective effect. And on the judge's findings, it's plain that pre-Cattolica, Venice had capacity to enter into these swaps. And it was Venice's own case, which is why this would have been it's difficult to say further evidence would have been required. It's Venice's own case that Cattolica was unforeseeable. The second point is I've made as permission to appeal. It's a pure point of law. It provides a complete answer to Venice's argument based on Cattolica, and there's no prejudice to arguing it now. The third point is, as a matter of the English conflict of laws, the capacity of a foreign legal person is to be determined by reference to the law as it stood when the relevant legal entity purported to exercise its powers. English law will not apply an unforeseeable judicial decision which purports retrospectively to deprive that legal person of the capacity which it had at the time. and an English law contract cannot be retrospectively discharged by such a law. And the fourth point, and in the alternative, to give effect to the decision in Cattolica would be contrary to public policy because it would be inconsistent with Article 1, Protocol 1. So the premise of the argument is obviously that Cattolica was a retrospective and unforeseeable decision. So can I take Venice's pleadings to show you that and make it good? So that's in the core bundle at tab 17, it's volume 2. So this is Venice's re-amended defence and counterclaim. And it's page 416 in the hard copy. And this is in a section dealing with a claim by the banks against Venice for breach of Article 1338 of the Italian Civil Code. And that Article 1338 of the Italian Civil Code, which you see referenced on this page, provides that if one party knows or should know of the invalidity of a contract, the other party reasonably believes the contract is valid, then the former has to pay compensation. So it's you can't sit on knowledge that a contract is invalid. And the banks argued that if there was a restriction on capacity, then Venice ought to have known about it. And Venice denied that claim, and you see that at 78S on the very top. So this put the foreseeability of Cattolica, the decision in Cattolica, squarely in issue on the pleadings. If we could then go over to the next tab, tab 18, which is the reply, and it's page 468. And it's 51H subparagraph 2, so it's subparagraph 2 on this page. This is the reply on the point I've just shown you.
Sorry, what page?
It's 468, my lord,
Thank you very much.
and it's subparagraph 2, which is the reply to the paragraph I've just shown you.
Is that right? So I'm good. If this is the reply to 78S, it's paragraph 51J at the bottom of 469. This is making the point that it wasn't. This is the point that Cattolica didn't propound any new principle in Italian law.
Exactly, and I was coming on to...
Even if it did, they knew.
Yes, my lord, and I was coming on to then to show you over the page, exactly as you say, the response in that context then to 50, and it's 51J,
Yeah.
that goes on to say specifically Cattolica in that context.
Yeah.
And the whole of the section replies on the knowledge and foreseeability in that context.
So there's something of a multiface on your part, isn't there? If you're pleading here that they should have known and it was all foreseeable. And, the municipality of Cattolica issued proceedings in March 2007. And now you're saying, well, actually it wasn't.
No, I'm simply saying on the judge's findings, it was not foreseeable. And I'm showing, and the response to that from my learned friend is, oh, if that had been an issue, if you were going to take this point, we would have needed further evidence. And what I'm just showing you is the question of whether or not it was foreseeable was on the pleadings, and Venice's case was it wasn't foreseeable. So it's hard to see now on this application for permission and this ground how it could be said that a different set of evidence would be required, given their stance on the pleadings, and given it was an issue, and given that disclosure could have been made had they taken the stance they're taking on ground 4, etc. So,
Just as a matter of interest, is there an equivalent plea to that in 51J2, specifically 51J2, in relation to reliance on section 32(1)(c) of the Limitation Act, which is
the banks
the
took their...
fifth ground.
So the banks have taken a limitation point in the reply to defence to counterclaim, which I
Yeah.
was going to show you. And if we go then to, the bank took the limitation point, and if the pleaded response, I think, is at tab 19, page 513. Yes, exactly. So this is the plea on limitation.
Yeah. Okay.
I think this is what your lordship had in mind.
Yeah.
As your lordship knows, we say this isn't right for limitation, and we'll come on to that ground. But at the moment, what I'm focusing on is the proposition that Venice would have taken some different stance, that Cattolica
Yeah. Okay.
was foreseeable for the purposes of this ground, which they are suggesting. Now, if we then go to the judge's findings, on which I'm relying for the purposes of the retrospective change, it's paragraph 276, which I have already shown you, but it's worth looking at again in this context. And the wording have completely altered the legal landscape and so on. And then 381 is the next relevant paragraph on limitation. Sorry, 381 is leading into limitation. I'll come on to show you limitation. So the judge's findings are clear as to it being a new development. And just picking up on my Lord Justice Mayall's question, I think, earlier in the day, the necessary consequence of this finding is a reasonable person in Venice's position at the time of contracting would have understood it had capacity to contract under the law as it then stood. If we go then to paragraph 430, this is in the limitations section, which starts on page 315, paragraph 426. And 430 is at page 317. And I'll come back to these paragraphs, obviously, in the context of limitation.
Yeah.
But drawing the threads together, the question of whether Cattolica was foreseeable for the purposes of this ground was squarely an issue below. The judge made clear findings in multiple places that the decision was unforeseeable because it was a change in Italian law to how it was understood when the parties entered into the contract. And I've already shown the court the prior legislation and Mrs Justice Cockerell's observation that absent Cattolica, there would plainly be capacity. And the retrospective effect of the decision is also undeniable. And the judge found that the decision had retrospective effect because the contracts would have been valid and binding under Italian law, but not post-Cattolica. So with that, against that landscape, I then turn to our application for permission to appeal. And the starting point is that the ground has significant merit. It's a very important point of English law which provides a complete answer to Venice's reliance upon the Cattolica case. And I will develop the merits as I continue. But just tackling the preliminary submission made by my learned friend at paragraphs 7C and 90 of his skeleton argument, he says there would have needed to be factual or expert evidence as to the extent to which what Italian law was at the date of the transaction, the extent to which subsequent changes were foreseeable, and the extent to which judicial decisions can be regarded as retrospective changes in law. But the point is that on the face of the judgment, the judge has made findings about all three of those points because they were specifically in issue, and he set out the state of the Italian law as at the date of the transactions, and there's no dispute about that. He set out that Cattolica was unforeseeable, and he set out that it has a retrospective change in the legal status of the doctrines of Italian law. So it's not clear at all what it is that my learned friend says would have been needed to be produced and how that was consistent with his case below. And he continues to rely on the judge's findings as to the unforeseeable nature of Cattolica for the purposes of limitation. So, my lord, we say that there's no prejudice here. It is a point of law, and it's on the basis of the findings made by the judge, which are very clear. And more than that, it's very difficult to see what further evidence could sensibly have been adduced on this point. So that brings me then to my third point, which is the meat of the submissions on this head. And in summary, we say that under English law, the capacity of a foreign legal person is to be determined by reference to the law as it stood when the relevant legal entity purported to exercise its powers. And English law will not apply an unforeseeable judicial decision which purports retrospectively to deprive that legal person of the capacity which it was understood to have at the time. And it would be wrong in principle for a foreign law to be capable of retrospectively discharging English law payment obligations simply because the foreign law is dressed up as a restriction on capacity. And so we say the judge was wrong in where he ended up on the case. And it's just stepping back before I show you the cases on this head. The consequences, if the judge was right, that Cattolica rendered these and therefore many, many other English law governed financial transactions as void under the ISDA Master Agreement. Some 13 years later, because of an unforeseeable judicial decision in Italy, it is both remarkable and potentially monstrous for this jurisdiction. And it's monstrous for two reasons. One, because it plainly undermines the sanctity of English law in a very serious context of ISDA international transactions on standard form agreements, which this jurisdiction has always respected and upheld. And secondly, it's monstrous because it would leave English law contracts subject to the shifting sands of potentially ever-changing Italian decisions. Because who's to say that Cattolica is the last word? And where would that leave this jurisdiction? As of now, it would leave hundreds of transactions potentially to be unravelled. Some of those transactions have already been ruled upon in the Commercial Court and Court of Appeal, the case of Savona being one of them. And it would leave them all open in hypothesis to be revisited, subject to limitation points. And it could then leave a wave of further litigation, potentially, if the Italian courts change their minds again, because the political climate in Italy changed, and it was considered helpful for local authorities to borrow, just as we saw was the position earlier in the history of the legislation. And it could be never-ending. And English law clearly cannot be subject to that form of uncertainty, still less in the ISDA financial context. And what you will see when I show you the cases is a recognition of that in the context of things like wills and also English law financial obligations. So it's very clear that there is the authority on those points. The point of distinction that I think my learned friend will try and argue is that because this is capacity, it's somehow different. But it really can't be, because it has the same, without wishing to hype it up, monstrous effect that Lord Reed observed would not be permissible many years ago. So if I could show you first of all the Lynch case, which is in the authorities bundle at tab 2. And just for my Lord Justice Mayors, we will be coming back to Nelson and Bridgeport as well. So this is a case concerning the president of Paraguay, who died leaving property in England, and you see that on page 13 of the bundle, page 19 in the electronic bundle at paragraph 1. 2 months later, the provisional government passed a retrospective decree invalidating his will and confiscating his personal estate wherever in the world it was situated. You see that in paragraph 3. The President's universal legatee can claim probate under the will in England, and the provisional government objected on the basis of the decree. And it was common ground that the right to succeed to the President's personal property was governed by the law of Paraguay, that being the law of the President's domicile. However, the court here held that the law of Paraguay had to be applied as it existed at the time of death, and that the subsequent change in law was irrelevant, even though the decree would have been applied by a court in Paraguay. And if we could go, please, to page 16 of the hard copy bundle, or page 22 of the electronic version. And we're looking for the paragraph that starts, or the sentence 4 lines down, I am satisfied.
I'm satisfied the date of the decree
Relied upon by the defendants is fatal to their claim in this suit. The general proposition that the succession to personal property in England of a person dying domiciled abroad is governed by the law of the actual domicile of the deceased was not denied, but it was affirmed by the plaintiff that this proposition had relation only to the law of domicile as it existed at the time of the death of the individual in question, and that no changes made in the law after that date can be by the law of this country recognised as affecting the distribution of personal property in England. And then if we go a little bit down the page to the sentence that starts, but it was ingeniously argued, which is sort of a third up from the bottom.
Yeah.
And read that and you'll see that the point was made that the Court of Paraguay would be bound to enforce the decree. That may be so, but the question is whether the English courts are bound in a like manner, or what's the law that is adopted by the English Court of Domicile. And if you could read over the page till the end of the paragraph, the demurrer must therefore prevail. So pausing there, this deals with one of Venice's counter-arguments on this part of the appeal, because Venice submits that the task of the judge was to apply the law as it would be applied by the Supreme Court of Italy, and to refuse to recognise Cattolica would be to apply the law differently from how it would be applied in Italy. Now, on this ground, the position is, as you can see from Lord Penzance's judgment, that's overlooking the fact that the English task here was to decide whether rights are required at a given point in time, i.e. death here. And we say that the same applies to the contracts that this court is looking at. This case was a case concerned with succession, not the law of capacity, of course. But in our respectful submission, there's an important similarity that can be drawn, because both concepts, succession and capacity, concern the exercise of a power at a point in time, specific point in time. Succession is the final exercise of the power to dispose of property at death, and those who succeed to the property of the person who's died acquire rights which they did not have beforehand. That occurs at a single point in time, which is death, after which new rights are created, and those new rights are then governed by the law where the property is situated, and if the property is situated in England, the property rights are governed by English law. And it's English law thereafter which sustains those rights, and subsequent changes to the prior law, here Paraguay, are irrelevant. Now we say the same framework applies to our case. Capacity means the substantive power to create contractual rights and obligations. The power is exercised at the time of entering into the contract. At that point in time, a party either has capacity or it does not. If there is capacity, then new rights are created, which in this case are governed by English law, and it is English law which sustains the contract thereafter, and subsequent changes of Italian law are irrelevant. Can I then show you, in the context of a financial situation, the case of Adams and National Bank of Greece, another House of Lords authority, and that's in volume 2 at tab 15. And that's page 500 or 506 electronically.
Page 500.
Page 500 of the authorities bundle, or 506, my lord, in the
Curiously,
electronic
my
version.
electronic version starts at page 500. which is
It's tab
interesting.
15, does
Yeah.
that help you?
Yep.
Thank you. Sorry about that. So in summary, my lord, this case concerned English law bonds and guarantees, and the facts are quite spread out, but they come very clearly from Lord Reed's judgment, which is page 521 of the bundle as I have it. If I look at the top left-hand corner of the report, it's 276.
Yeah.
And that may be 527 of the some people's some judges' electronic versions.
276.
And you see from Lord Reed's introduction that the case concerned English law bonds and guarantees. The bonds were issued by the National Mortgage Bank of Greece and guaranteed by the National Bank of Greece. And under a Greek law passed in 1953, the old National Bank of Greece was dissolved and a new Bank of Greece succeeded to all of its rights and obligations. And the bondholders then brought claims in England under the guarantees against the new Bank of Greece. And you see that all over the page. Shortly after those claims were commenced, the Greek government passed another law which amended the previous law to exclude foreign currency obligations, including guarantees, from its scope. And so under Greek law, that meant that the new Bank of Greece never acquired the rights in the first place as part of the succession from the old bank to the new bank. And Lord Reid found at 523, so 278 of the report, in the middle of the page, there is no doubt that the new law is valid in Greece. The new Bank of Greece then argued that by reason of the recently passed law, it had never acquired the rights and obligations under the guarantees and was not liable to the claimants. And at first instance, Mr Justice Diplock, as he then was, rejected that argument, but the Court of Appeal reversed that decision on the basis that the law of the place of incorporation governed questions of succession. And in particular, Lord Justice Morris said that what the law of incorporation could give, it could take away. And the House of Lords unanimously reversed the Court of Appeal's judgment and held that the new law did not affect the new bank's liabilities. And each of their lordships gave a judgment which are worth reviewing. So starting with Viscount Simmons' judgment, which starts at page 272 of the report, so 517 of the hard copy or 523.
I'm not
judge-
really going to finish looking at these judgments by 4:30. I wonder whether it might be more sensible for us to look at the judgments tomorrow morning.
My Lord, I don't know if the court would be happy to start a touch earlier, because I'm just conscious of time. I have to finish this
How
ground
are you
and
doing?
limitation.
On time. How are you doing on time?
I'm doing all right, but I would benefit from any more I can get.
Can we sit at 10:15? 10:15? We sit at
Thank you.
10:15. 10:15 tomorrow.